Hello, everyone, and welcome to Uncivil Law. And for today's stream, I got some proper law nerd stuff for you. So if you think you're a law nerd, this is the place you want to be. This is some real geeky law nerd stuff. It deals with interaction between federal and state law and deals with exhaustion doctrine, both as it relates to state and federal law under 1983 claims against the state. Really, really geeky stuff. This is some hardcore geek law time. So we're going to have a lot of fun on this one. This is going to be a good one. We turn our attention to Williams versus Reed in their capacity as Alabama's Secretary of the Workforce. So Williams versus Alabama by another name. The facts are as thus. The petitioners are unemployed workers who contend that Alabama's Department of Labor unlawfully delayed processing of their state unemployment benefit claim. All right, great. So I've been unemployed. I'd like some unemployed benefits, please. And Alabama doesn't say yes. They don't say no. They say, please wait. Your call is important to us. Your call will be answered in the order presented. And then they just stay on hold, basically indefinitely. It's like, we're not going to say yes and we're not going to say no. We're just holding on to your paperwork and we're processing it. We're going to get around to it eventually. It's like, okay, well, that isn't quite working for me. So they're not really happy with that plan. So they sue the Alabama Secretary of Labor in state court under 1983 federal claim, raising due process and federal statutory arguments and seeking a court order requiring the department to process their claims more quickly. It's like, okay, well, I believe that you have violated federal law by taking too long to process my claims. And this is where it gets interesting. This is where it gets interesting because under federal law, you have to exhaust any administrative remedies you have before you can go to court. You can go to court, but you have to exhaust your administrative remedies first. So if you have a problem with an administrative agency, then you have to go through the process of the agency to seek resolution, usually before some sort of administrative court. And that's how you get your resolution from the agency. And then if you're still unhappy with that, then you can go to federal court. This serves multiple purposes, not the least of which is it makes the federal court's life a little bit easier. Because like maybe if we just sit back and let them try, they'll get it right and we don't have to do anything and we can make our docket cleaner. And so that would be nice. And so we have exhaustion doctrine. Now, what's interesting is under state law, there is not necessarily this requirement. There's not necessarily a requirement to exhaust your remedies. States can do it, they cannot do it. But there's generally speaking not an exhaustion requirement. So you can sue even though you haven't exhausted your remedies first. Typically, exceptions apply. So this is where it's interesting because it's like, okay, I'm suing under a federal law. But I'm suing under a federal law based on state process rather than federal process. So like, which rule is it now? Do I have to exhaust my state level process first, or don't I? Because this is a federal law. And so this is like this is interaction between federal state government. This is dealing with different rules on getting your exhaustion. This is dealing with this. So this is some proper law nerd stuff, right? This is real hardcore stuff. Okay, great. The Secretary of Alabama moved to dismissal on several grounds, including the state trial court lacked jurisdiction because the claimants had not satisfied the relevant statutes' strict administrative exhaustion requirements. So they're like, you can't sue us in state court, which incidentally they did, which also makes things complicated, right? They didn't sue in federal court. They sued in state court on a federal cause of action. Now you can do that. You can sue in state court on a federal cause of action. Why they didn't file in federal court, I don't know. I'm sure there was some interesting reason why they didn't. So they didn't file in state court. They didn't file in federal court. They filed this complaint in state court. And they're like, you violated federal law. Please, state judge, tell them they have to follow the federal law. And so Alabama has come back and said, well, you can't sue us in state court because you haven't exhausted all your remedies yet. So you don't have, the state court doesn't have jurisdiction. Because under our law, you have to strictly exhaust everything, and you haven't done that yet. Right? But they're like, but I'm suing under a federal cause of action, but I'm suing in state court. So again, like, which one wins, right? Do I have to follow the state level process or the federal level process in state court with respect to a federal level proceeding? I told you this was proper law nerd stuff. This is good stuff, man. All right. The state trial court granted the secretary's motion and dismissed the complaint, leaving the claimants in a catch-22, unable to sue in order to obtain an order expediting the administrative process because they had not yet completed the process being delayed. And it's like, yeah, so we left you with it. So the state court's like, no, I can't hear the case. And now you're just screwed. It's like, you can't sue me because you haven't exhausted the process, even though the very thing you're suing for is failure to give you process. Right? And so it's a catch-22, but be that as it may, that might be the right legal answer. So that's what the state court says. Like, I can't hear your case. You have to go exhaust your remedies and, let us know when that happens, however long it takes. Okay. Yeah. Tony says I'd apply federal rules, but I'm not a lawyer. I remember when this case was being petitioned. We covered this case when it was being petitioned on the channel, and I didn't know the answer. I thought it was really, really interesting case. We talked about this case when it was being petitioned. And I was like, oh, I don't know what the answer is. So yeah, it's like I wasn't sure either. So I'm right there with you, ma'am. The Alabama Supreme Court affirmed on failure to exhaust, concluding Section 1983 did not preempt state administrative exhaustion requirements. Cool. All right, so the Supreme Court resolves this interesting tension by saying the following. Where a state court's application of state exhaustion remedy in effect immunizes state officials from 1983 claims challenging delays in the administrative process, states courts may not deny those claims on failure to exhaust. So a somewhat narrow ruling, but it's like, we're going to give you a little bit of an out to get out of the catch-22. So we're not saying that you don't have to exhaust state level remedies normally. We're not saying that. But we are saying that when this basically immunizes you because we're just not going to give you process, you can't do that under 1983. So that is not permitted. The court continues to write the following. The Supreme Court writes the following. A state law that immunizes government conduct otherwise subject to suit under 1983 is preempted, even where the federal civil rights litigation takes place in state court. So fair enough, right? So if 1983 is applicable, then 1983 obliterates immunity to some degree at least. And so the state level immunity is not the thing. The federal level immunity, such as it might exist, is the thing. Thus, in Howat versus Rose, this court held in 1983 preempted a federal rule extending state sovereign immunity from 1983 courts to 1983 suits to municipalities, counties, and school districts because in effect afforded immunity from certain 1983 things. So again, like 1983, 42 USC 1983, at least in part, abrogates state level immunity. And so the state can't give itself immunity from a 1983 lawsuit by saying, well, we're just immune. It's like, no, 42 USC 1983 is meant in part to abrogate that immunity, and obviously the federal law controls. So not so much. Thank you, Florida, for your interesting contribution. And in Haywood versus Down, this court held a New York statute designed to shield corrupt officers from damages claimed by prisoners was also 1983. So also New York tried this. It's like, you can't sue the prison officials. It's like, yes, you can. Under 1983, you can. Right? We're just dealing with immunity issues, by the way. Like, can I bring suit? I mean, those of you who follow the channel know that bringing a suit under 1983 is very challenging because you need clearly established federal law. But we're just trying to figure out whether or not you can even file at all. And then what you have to prove is a whole other set of problems. So we're going from it's impossible to almost impossible, right? That's the move we want to do. And New York and Florida were like, we want to move from almost impossible to actually impossible. And the Supreme Court said you can't do that. Almost impossible is as good as it gets. Okay? Under Alabama's exhaustion requirement, state courts cannot review claims of unlawful delays under 1983 unless and until the claimants first complete the administrative process and receive a final decision on their claims. Such a requirement operates to immunize state officials from the narrow class of claims brought under 1983. Under this court's precedent, Alabama cannot apply such immunity. So, not so much. According to the Secretary, the jurisdictional nature of Alabama's exhaustion provision distinguishes it from state-level rules at issues in the prior case. So they're like, okay, we're not saying that we have immunity. We're simply saying the state's courts don't have jurisdiction. They don't have jurisdiction. And it's like, no, we appreciate your creative attempt, but no. Right? But now, incidentally, by the way, I think it would be okay if the state said you couldn't bring any federal level complaints in state court. I think they could do that. Now, I don't know if they would want to, but I think they could, right? So the issue isn't necessarily, can Alabama say no 1983 claims in state court? They might be able to do that because that would be commandeering doctrine, right? You're commandeering state courts to effect a federal level law. And it's like, so commandeering doctrine would seem to pop in. So if Alabama or any other state said simply, okay, you can't file a 1983 claim in state court at all, they might be able to do that, right? If you have a federal cause, go to a federal court. That's what they're for. You know, go forth, my friend, right? They might be able to do that. But they didn't say you can't file the 1983 claim at all. They said you can't file it unless you exhaust all your remedies. And so that was the problem. You can't do that. Okay? But this court's precedent, the Supreme Court speaking for itself, this court's precedents have not treated the jurisdictional label of state rules as dispositive when state rules functionally immunize defendants from a class of 1983 claims in state court. Note, a class of claims as opposed to all claims, maybe being a distinction. In Haywood, for example, this court said the jurisdictional status of the New York rule did not insulate from preemption. Again, you can't bring the claim at all. Just you can't bring it unless, and the unless thing is where it gets tricky. Next, the Secretary suggests that any delays in state administrative proceeding can be cured by the claim seeking a writ of mandamus from the state court to compel the department to act more quickly. It is not, however, evident that the mandamus is available to claimants here. So they're like, well, you could just get a writ of mandamus, but the Supreme Court's like, we're not sure if you could anyway. And, we still have something to say on the issue. In any event, the Secretary's argument is simply another way of saying a claimant must go through a state-level process before stating a claim under 1983. So getting a writ of mandamus would be the state-level process. Just as Alabama may not foreclose plaintiffs to complete the state administrative procedure process before plaintiffs may sue under 1983 to challenge allegedly unlawful delays, the state may not force plaintiffs to seek mandamus before bringing those claims. And we have an opinion in a sharply divided court. Kavanaugh delivers the opinion of the court in which Roberts, Sotomayor, Kagan, and Jackson join. So an interesting split. You don't see that split every day. Kavanaugh and Roberts is more understandable. Kavanaugh is a swing justice. It's like you don't normally see, that's a little bit odd. So Kavanaugh joins Roberts and the liberals to render the opinion. Thomas files a dissent in which Alito, Gorsuch, and Barrett join as to at least part of the dissent. So a 5-4 decision by the U.S. Supreme Court. Very, very interesting and very, very geeky. And without reading it, I suppose at some point we could try to read the case in detail and try to figure out which of these arguments are best argument, depending on whether or not people want to see that. But it would be a detailed stream. So if you guys want to see that kind of thing, let me know and put it in YouTube comments. And if there's enough of you guys who say you want to see that, then we can go through the opinion in detail and try to suss out which opinion is best opinion. Because based on the summary nature of the syllabus, I think it makes sense, but I'm fully open to the possibility there's a better argument by dissent. Yeah, I'm fully open to the possibility there's a dissent. And we didn't even really read the majority opinion. We just read a summary of it. So maybe the majority's reasoning leaves something to be desired. It's only 26 pages. I'll just do it now, actually. It's only 26 pages. If it were longer, I'd do a more detailed one. But it's only 26 pages. I can do it now. Let's just do it now. Screw it. All right. Let's read Justice Kavanaugh's majority opinion, and then let's read the dissent. Alabama has the longest state constitution. I would be shocked if it was not Louisiana. I'd be shocked if Louisiana wasn't longer than Alabama. But let me know. In any case, Justice Kavanaugh delivers the opinion of the court. Several unemployed workers in Alabama apply for unemployment benefits from the state. In their view, the Alabama Department of Labor has unlawfully delayed the processing of their benefit claims. So the claimants sued the Alabama Secretary of Labor in state court under 42 U.S.C. 1983, raising due process and federal statutory arguments and seeking a court order requiring the department to process their claims more quickly. The Alabama Supreme Court ruled the claimants could not sue under 1983 to challenge delays in the administrative process unless complainants complete the process. But that ruling created a catch-22. Because the claimants could not sue until they complete the administrative process, they can never sue under 1983 to obtain an order expediting the administrative process. This court's precedents do not permit the states to immunize state officials from 1983 suits in that way. On this narrow ground, we reverse. I mean, it is pretty narrow. I think that much is true. It's a fairly narrow decision. The state of Alabama grants monetary benefits to unemployed claimants who meet certain eligibility criteria. To obtain unemployment benefits, a claimant must first file with the Alabama Department of Labor in accordance with general rules as the secretary may prescribe. After receiving the application, the department, through an examiner designated by the secretary, must promptly make a determination on the claim. The department also must promptly notify the claimant of their determination, generally by mailing a notice to his or her last known address. The relevant provisions, of course, do not define promptly because that would be too easy. A claimant who wants to appeal an adverse determination must, within 7 days of delivery of the notice or 15 days of the mailing of the notice, seek review by the appeals tribunal. That tribunal consists of a department employee who is appointed by the secretary. The tribunal must hear and decide disputed claims and other due process claims related to benefits, and the tribunal must promptly hold a hearing. The tribunal must then decide the appeal within 30 days of the hearing. A claimant who loses before the appeals tribunal may seek discretionary review before the department's Board of Appeals, which is composed of 3 members appointed by the governor. A claimant must seek review within 15 days from the date in which the appeals tribunal decision was mailed. If the Board of Appeals does not grant review within 10 days of the claimant, then the decision of the appeal tribunal becomes final. After the Board of Appeals denies review, fails to grant review within 10 days, or grants review and issues an adverse decision, the claimant may then challenge the denial of benefits in Alabama state court. But not until then. The Alabama law setting forth these procedures includes a strict exhaustion requirement which provides, no circuit court shall permit an appeal from a decision allowing or disallowing a claim for benefits unless the decision sought to be reviewed is that of the appeals tribunal or the Board of Appeals, and unless the person filing such an appeal has exhausted his administrative remedies as provided in this chapter. So strict review. That statutory procedure shall be exclusive. On its face, the state exhaustion requirements prevents claimants from challenging adverse benefit determinations in state court, including suits brought under 1983, until the Board of Appeals has denied review. In this case, 21 Alabama claimants applied for unemployment benefits. They contend that the department in various ways has unlawfully delayed the process of their benefit claims. For example, plaintiff Derek Bateman alleges they attempted to appeal his claim to the appeals tribunal. But according to Bateman, the department never scheduled a hearing or otherwise acted on his appeal, even after he attempted to follow up with email and phone calls numerous times. The 21 claimants sued the Secretary of Labor in his official capacity in the Circuit Court of Montgomery County. Invoking 42 U.S.C. 1983, they asserted, among other things, the department's delays in processing their claims violates due process of the 14th Amendment and the Social Security Act of 1935. The claimants did not ask the court to rule that they were entitled to unemployment benefits. Rather, they simply asked the court to order the department to promptly address their benefit claims. As relevant here, the claimants sought a court order requiring the department to issue an initial non-monetary decision within the next 10 days to every plaintiff who's not yet received a decision, provide within 10 days a hearing date for each plaintiff who's requested a hearing, schedule such a hearing date for not later than 90 days after a request for the hearing, and pay every approved claim within 2 days of approval. The Secretary moved to dismiss the complaint on several grounds. The Secretary argued, among other things, the state trial court lacked jurisdiction because the claimant had not satisfied the administrative exhaustion requirements of the relevant state law. The court granted the motion and dismissed the complaint. The complainants appealed to the Alabama Supreme Court. There, the court affirmed on failure to exhaust grounds. The court concluded that under the state's court's precedent, 1983 did not preempt the state's administrative exhaustion requirements, which definitely was a bit of an open question, to be sure. Justice Cook of the state court dissented. He reasoned that under this court's 1983 precedent, the state could not bar a suit challenging the department's delays in making a determination. This court grants certiorari. The Secretary argues that Alabama's exhaustion requirement contains a neutral rule of judicial administration, and that Alabama Supreme Court permissibly applied the statutory rule to bar the claimants in 1983 in state court. The claimants respond that Alabama may not preclude the 1983 suits on failure to exhaust grounds, whereas here, plaintiffs challenge the department's delays in processing their claims. Otherwise, they say Alabama's rule would create a catch-22, preventing adjudication of and in effect immunizing state officials from this narrow category of 1983 claims about delays in the administrative process. In light of this court's precedent, we agree with the claimants. In the unusual circumstances presented here, again, just like flags everywhere, like this is a narrow decision, right? So like we're not trying to upset the entire apple cart. We're just trying to fix a very small problem. Now, of course, whether it stays there in the long term is a whole nother set of issues, but the Supreme Court is trying to tell you that this is fairly narrow. And so like, don't go out of your way to extend the scope. In the unusual circumstances presented here, where state court's application of state exhaustion requirement in effect immunizes officials from 1983 claims challenging delay in the administrative process. Claims challenging delay, state courts may not deny those on failure to exhaust grounds. This court has long held that a state law that immunizes governmental conduct otherwise subject to suit under 1983 is preempted even where the federal civil rights litigation takes place in state court. To the extent that 1983 is the law, then yes, that makes sense. Federal preemption makes sense. So what 1983 says, then yeah, the state can't preempt that. But then again, we're in federal court on exactly that issue. What does 1983 say on this issue? And we're trying to create new law, and we're about to. So that's exciting. As the court has explained, states possess no authority to override congressional decision to subject state officials to a liability for violations of federal rights. That principle bars any state rule immunizing state officials from a particular species of federal claims, even if the immunity rule is cloaked in a jurisdictional garb. So we don't really care what the label is. We don't care what the label is. The label is not the thing, as often is true in law. In Howlett versus Rose, for example, the court analyzed a federal rule extending state sovereign immunity from 1983 suits not only to the state and its arms, but also to municipalities, counties, and school districts that might otherwise be subject to the suit under 1983. This court held that under 1983, it preempted federal rule because the rule in effect afforded immunity from certain claims. And in Hayward versus Don, the court addressed New York statute depriving state courts of jurisdiction over claims by prisoners seeking damages against state correctional officers. The court reiterated a state lacked authority to nullify a federal right or cause of action they believe is inconsistent with their policies. In violation of that principle, New York has in essence created an immunity defense for correctional officers when the officers were sued under 1983. The Hayward court held that the unique scheme adopted by the state of New York, a law designed to shield a particular class of defendants, correction officers, from a particular type of liability, damages, brought by a particular class of plaintiffs, prisoners, was preempted by 1983. And then also they note in a footnote here, in Hayward, this court declined to address whether Congress may compel a state to offer a forum otherwise unavailable under state law to hear suits. This case does not require us to present that question. So as I sort of said earlier, right, there's no decision that says a state must hear 1983 claims. But if you do hear 1983 claims, that comes with a whole bunch of federal baggage because it's a federal claim. So can the federal government force a state to hear the claim? Almost certainly not. Almost certainly not. Preemption doctrine or commandeering doctrine, anti-commandeering doctrine. The federal government can't commandeer the states. So if the federal government wants to enforce its own law, it has its own courts. So, go do that. So states can do it. States do it. But I don't think the federal government can force it, but that issue is not raised here. Right? It's not, can Alabama say we're not going to hear any claims under 1983? That's not the issue. It's like, given that we're going to, can we impose exciting rules? The answer to which is maybe you can impose some exciting rules, but not necessarily all exciting rules. So you're not necessarily completely bounded, but you're definitely not unfettered. Here, the Alabama Supreme Court ruled the state's exhaustion requirement applies to procedural challenges related to administration of unemployment compensation benefits, in addition to substantive challenges regarding the decision to award or not award those benefits. And they conclude that the universe of procedural challenges requiring exhaustion includes 1983 suits alleging the department is unlawfully delaying the process of the benefit claims. Alabama's exhaustion requirement operates to immunize state officials from a narrow class of claims brought under 1983, namely the unlawful delay in the administrative process. Under Alabama's exhaustion requirement, state courts cannot review claims under unlawful delays under 1983 and unless and until claimants first complete the administrative process and receive a final decision. In essence, Alabama said that to challenge delays in the administrative process, you first have to exhaust the administrative process. Of course, that means you can never challenge delays in the administrative process. Not in state court, you wouldn't be able to. That would be true. That catch-22 prevents the claimants here from obtaining a merits resolution of their 1983 claim in state court and in effect immunizes state officials from those kinds of claims. So it is a catch-22. That is true. Under this court's precedent, however, Alabama cannot maintain such an immunity rule. As this court's cases repeatedly held, a state law that immunizes governmental conduct otherwise subject to suit under 1983 is preempted, even where the federal civil rights litigation takes place in state court. In response, the Secretary advances two primary points. First, the Secretary argues that the jurisdictional nature of Alabama's exhaustion provision sets it apart from procedural rules that may be more readily preempted. In particular, according to the Secretary, the jurisdictional status of Alabama's exhaustion requirement distinguishes it from state-level rules in the other cases. States retain substantial leeway to establish the contours of their judicial system and are free to enforce a neutral jurisdictional rule. The Secretary's argument fails, however, because this court's precedent have not treated jurisdictional label of state rules as dispositive when state rules functionally immunize defendants from the class of claims. Or even more broadly than that, right? The label is not the thing. The label is not the thing. So you can find plenty of decisions from the U.S. Supreme Court in many different contexts where like, well, I know that they called it this, but it's really this. Amazingly enough, people have tried to skirt around things by like, what if I call it something different, right? What if I just give it a different label? And no, you can't really do that. The label is not the thing. In Haywood, for example, a New York law withdrew the state court's jurisdiction over a class of 1983 claims against correctional officers. The court stated that the jurisdictional nature of the rule did not insulate the rule. Fair enough. As the court explained, New York law operated as an immunity statute cloaked in jurisdictional garb. To treat the jurisdictional label as dispositive would allow the supremacy clause to be evaded. The label is not the thing. I understand this concept. Second, the Secretary suggests that claimants could seek a writ of mandamus from the state court to compel the department to act more quickly. For that reason, the Secretary says any delays in the state administrative process can be cured within the state judicial system. To begin with, it's not evident that mandamus is available to the claimants here. The Secretary cites a lone, decades-old case from an Alabama intermediate appellate court suggesting in dicta that mandamus would be appropriate in a case where the state agency intentionally delays its decision. So like the state is, of course, in ultimate control of its state law. We know that, right? Even the U.S. Supreme Court cannot overturn a state as to its own state law. But, it's like, well, we can't help noticing that you say you can seek mandamus, and it's not really clear under your state law they can. So not so much. Maybe if it was clear that they could, maybe they had to do that first. Maybe that's fair. But it's not clear that they could. So no. If mandamus relief were available in these unemployment benefit cases, one would have expected the Alabama Supreme Court to say so in its opinion. Yet the court did not say or even suggest mandamus relief would be available. So as the Alabama Supreme Court was deciding this, they're like, oh, you could have, sought mandamus. which incidentally, by the way, the Supreme Court would then be within its rights to convert the cause of action into a mandamus. So, right, it's like, oh, I know you asked for this, but let me give you this other thing that gives you relief. So they could have done that, but they didn't do that. They didn't even suggest that they could file it. So Alabama Supreme Court doesn't seem to think that that's necessarily a great option. Yeah. In any event, the Secretary's argument based on the supposed availability of mandamus is simply another way of saying the claimant must go through the process provided by the state before suing under 1983 to challenge delays. To be sure, the availability of mandamus relief in state court might be irrelevant to the merits of a due process or federal statutory claim seeking delay. So if you have the ability to seek mandamus and you haven't, then that might be relevant. But just as Alabama may not force plaintiffs to complete the state administrative process before they can sue, Alabama may not force plaintiffs to seek mandamus before they can bring the suit. Otherwise, by the time the plaintiffs could sue for injunctive relief, the claims might be moot. They might be done. They might be done. For its part, the dissent largely discusses issue that we do not address in this opinion. In part 2C2, where dissent eventually turns to the merits of our legal analysis, dissent argues that Haywood's reasoning about immunity rules applies only where a focus on the statutory purpose reveals a state law rule that reflects a policy disagreement with federal law. Yeah, that would be really weird. I mean, that's not normally how the Supreme Court does things, right? So sometimes states are dumb enough to say in their legislation, they're dumb enough to say the reason that we're doing this is because of reason X. And the court's like, well, reason X is really dumb. And so a lot of states are like, okay, well, I learned my lesson. I'm not going to state the really dumb reason, or maybe any reason at all. I'm not going to state the really dumb reason or any reason at all. I'm just going to pass the thing. And it's like, okay, we need an explicit statement from the state legislature that says, here's why we're doing the stupid thing before we can find it to be illegal. It's like, I don't think so. The stupid thing is certainly helpful for determining it's illegal, but to say it's required, no state legislature would ever provide a reason ever again. I mean, you know, that doesn't work. I don't like that rationale. The decision did not endorse a freewheeling inquiry into whether a state's rule or purpose or policy is at odds with federal law. Rather, a state rule runs afoul of the law if it operates as an immunity statute cloaked in jurisdictional garb by wholly barring a species. Again, what is it? Not the label, including the explanation from the legislature, which is like, we have really good and totally benign reasons, which maybe they do, incidentally. It's like, maybe they do have totally good and benign reasons, although maybe they also have some not so great ones. But like, once again, the label's not the thing. So your description of it is interesting and all, but, you know, not dispositive. The dissent also suggests claimants forfeit their argument in the Alabama Supreme Court. In that court, however, the claimants clearly raised the argument that under 1983, the state could not apply administrative exhaustion requirements to their claims. Yeah. I'm not sure how they forfeit the argument. That's interesting. Dissent further says our opinion may have ripple effects, but as we've emphasized, our opinion is narrow. It resolves the dispute, but is careful not to go beyond existing precedent. It's definitely attempting to be very narrow. It's definitely attempting to be very narrow, which makes it even more law geeky, right? Because it's like, we're trying to carve out this little tiny thing, you know, and not necessarily talked about broader issues. So, you know, fair enough. The Alabama Supreme Court interpreted the state's administration exhaustion requirement for unemployment benefits claims to in effect immunize Alabama's due process. By affording immunity to these claims, the Alabama rule contravenes. We therefore reverse the judgment. Well, that sounds like a pretty reasonable decision to me. That sounds pretty reasonable to me. But I am fully prepared to be sold by the dissent, because again, this is some maximum law geek. And when I read the complaint and the petition, I was like, ooh, I don't know. Right? I was like, ooh, I don't know. So I'm ready to be persuaded by the dissent. So, you know, sell me that you have the better end of the argument. All right, Justice Thomas, who Alito, Gorsuch, and Barrett join as to part 2, dissent. Okay, so one person for the majority. So mostly this is Thomas just musing some stuff, and then 4 people join some other parts. So they don't join the musings. I guess we'll read what Justice Thomas wrote for himself for a while. Alabama law requires claimants seeking unemployment benefits to exhaust their administrative remedies before suing over those benefits in state court. Petitioners, the claimants here, failed to complete that process before they sued. The Alabama Supreme Court accordingly held it lacked jurisdiction. That holding was plainly permissible. As a matter of first principle, states have unfair discretion over whether to provide a forum for 1983 claims in their court. I don't dispute that. I think that's true. If the state doesn't want to hear 1983 claims at all, I think they can do that. But they can't be like, we're going to hear 1983 claims and then also put restrictions on the federal law. It's like, if you buy into the federal law, you buy it, right? That's the deal. Like, if you buy the federal law, you buy it. And you buy everything that comes along with it. If you don't want to do it at all, I don't think they have to do it at all. But if you want to do it, if you want to buy it, it comes with all this baggage. So, deal. That's the deal, man. And Alabama's exhaustion rule does not transgress the limitations our precedents have recognized. This court concludes otherwise by endorsing an as-applied theory of futility that's both forfeited and meritless, moving our jurisprudence even farther off course. This case is relatively straightforward under first principles. Okay. Our federal system gives states plenary authority to decide whether their local courts will have subject matter jurisdiction over federal causes of action. Sure. I'm with you on that one. The Constitution allows states to hear federal claims in their court, but does not impose a duty to do so. I'm with you. Thus, once a state exercises its sovereign prerogative to deprive its courts of subject matter jurisdiction over a federal cause of action, that's the end of the matter. Again, if it was complete, I would be right on board with you. I'd be like, yep, no problem. If it was complete, I'd be chugging right along with you, Justice Thomas. Anti-commandeering doctrine, choo-choo, comes the train. All right, I'm right on board with you, but that's not what happened here. The only possible constraint the Constitution places on state jurisdictional discretion is the possibility that a federal statute may preempt state law. Yep. The Supremacy Clause makes the Constitution and the laws of the United States, which shall be made pursuant thereof, the supreme law of the land. Accordingly, federal law must prevail when Congress validly enacts a statute that expressly supersedes state law or where the state law conflicts with federal statute. No disagreement. This preemption rule raises the difficult question of whether Congress can require courts to entertain a federal cause of action. Again, no, for my money, but that's not the issue. So if it were the issue, I'd be on board with you, but no. And I don't think it's actually that difficult. I don't think that's that difficult. I don't even understand the difficulty, really. It's like, okay, federal law preempts state law. I get that. But why would it be necessary for that purpose that the state courts have to hear it? Just go to federal courts. Federal government, you have your own courts. Go to them. That's what they're for. You know what I mean? So why would you have to force the state to hear it? You don't need it. You don't need them. You got your own courts. Go do that. We need not answer the question because 1983 does not raise any preemption issue here. By the text, the provision does not command the states to provide a forum for the plaintiffs. Yeah. Instead, it merely addresses who may sue and for what violations of federal law. Nor does Alabama's exhaustion bar, which regulates a state court litigation, create any implicit conflict with 1983. Plaintiffs who do not exhaust their state remedies are always free to bring their claims in a federal forum. Okay, that's not necessarily the worst idea I've ever heard in my life. That's fair. Maybe you could just bring this in federal court and maybe that's the answer. That's not like a completely invalid opinion. So, I don't know if I agree with it, but it's a reasonable thing to say. Preemption analysis requires nothing further. Yeah, I have no problem. Preemption analysis is not my problem. This court proceeds to err to the extent they recognize a broader form of conflict preemption for state court process procedural rules that are perceived to burden the exercise of a federal right in state court. Okay. This form of conflict preemption targets state law rules that constitute an obstacle to the goals embodied in federal law. But only the federal law itself can support preemption under the Supremacy Clause. Extra textual speculation about Congress's purpose cannot. Fair, not completely unreasonable. Not completely unreasonable. So it's like only the statute, governs. and the federal law is in fact supreme, but I don't think this analysis works really in any other context, which is part of my problem with Justice Thomas, right? So that this argument doesn't work in any other context. So if I were in state level court just bringing a First Amendment challenge, just bringing a First Amendment challenge, the state court, to the extent it's applying the First Amendment, would have to apply the First Amendment law, including like every decision of the Supreme Court there too. And that's as to substance. And now you're talking about procedure, which, Erie does talk about the separation of process and procedure. So it's like, okay, we're just not going to allow you to do it as a procedural matter. But I suppose you could actually quibble whether it's really procedural actually at all, or whether it's substantive, which actually gets into interesting issues too, with what's a procedural rule and what's a substantive rule. See, for example, by comparison, anti-SLAPP provisions under relevant state law, under which there's a divide of authority in the federal courts. Not the least for a reason, by the way, that the different states have different SLAPP laws. But the anti-SLAPP law is a law that basically says it's a special motion to dismiss is what it is. The anti-SLAPP is a motion to dismiss. We gave it a different name. It has different rules, but it's a motion to dismiss. We just gave it a different name. Now, typically motions to dismiss are procedural. They're not substantive. So some states' courts have said the anti-SLAPP provisions are therefore procedural. And in federal court, you don't apply state-level procedural law. So the anti-SLAPP therefore doesn't have effect in a federal proceeding. But just because you write it procedurally doesn't necessarily mean it isn't substantive. And you can, because again, the label isn't the thing. So essentially, if there's substantive elements in the procedural thing, then it might become substantive, despite the fact it's written as procedure. And some federal courts have read the anti-SLAPP law that way. So that's part of that thing too, with the difference between process and substance. So if this were truly purely process, then Justice Thomas might be more on point. But I'm not sure that this qualifies as purely process, although maybe it does, to be fair. Maybe it does qualify as purely process. Again, this is like trying to draw these lines gets really tricky, right? Because I'm trying to draw a line in a very exacting way. And that's very tricky. It's tricky for a lawyer and it's tricky for a court. It's like the closer you want me as a lawyer or a court, the closer you want me to tell you where the edge is, right? The harder it is, right? That's why lawyers typically will give you advice that's like a 95% answer. Because the 95% answer is the answer the lawyer feels really comfortable with. Because like, I know this is the answer. If you go to a lawyer and you demand a 99% answer, or a 99.9% answer, or a 99.999% answer, right? It's like, well, my fees just went up from lots to fortunes because you want me to try to figure out exactly where the line is. The closer we want to dance to the edge, the harder it gets. So this is definitely, to Justice Thomas's credit, this line between procedure and substance and the degree to which this is a procedural rule is not necessarily trivial, and definitely is dancing more on the edge than your typical case, hence being law nerd. Law nerd to the nth. This is law nerd fuel. This is law nerd fuel big time, man. All right. Our precedents also err in establishing the requirement issue here. States' jurisdictional rule will be neutral, even in the absence of directly conflicting federal law. The Supremacy Clause does not, of its own force, constrain the state authority to define the subject matter jurisdiction of their own court. Typically, that's true. Rather, in making the Constitution and federal law supreme, it provides only a rule of decision that the state court must follow if it adjudicates the claim. I would therefore disregard our further limitation as demonstrably erroneous. Okay. Taken together, these cases should begin and end with Alabama's plenary authority to decide which federal matters in state courts will have subject matter here. Alabama exercised that authority to create exhaustion, and we should respect this decision. All right, so that was Justice Thomas writing for himself. Now we move on to Section 2, which has 4 people writing. So this is a 4-person dissent now. So 4 people write the following. This court should affirm even under existing precedent. Alabama's exhaustion requirement does not run afoul of the limitations this court has identified on state authority to restrict federal cause of action proceeding in state court. Petitioners misread our precedent in arguing otherwise, and majority theory likewise cannot pass muster. Although this court has held there are limits on states' discretion in regulating state jurisdiction over federal causes of action, our precedents emphasize state authority predominance. Fair. The general rule bottom deeply is in the importance of state control of state judicial procedure is that federal law takes the state courts as it finds them. Fair. Each state thus has great latitude to establish the structure and jurisdiction of its own courts. Also fair. This latitude allows states to decide which federal claims their courts can hear. As relevant here, our precedent establishes that states must exercise this jurisdictional latitude only through neutral rules that do not embody a policy disagreement. Based on this principle, we have identified 2 narrow exceptions to a state's discretion. First, the state may not refuse to hear a federal claim solely because it's brought under federal law. Well, I have to read that case more clearly, but it's like, yeah, I mean, that might be an interesting case to read more clearly, but I'm not going to do that right now. Second, a state may not deprive its courts of jurisdiction over disfavored federal claims, even if it simultaneously denies jurisdiction to identical state claim. When doing so would undermine federal law. Like, do what you want on state level law, that's your business, but federal law is our business. For good reason, no one suggests the first exemption applies. Alabama's exhaustion requirement by its terms does not discriminate against rights arising under federal law. Instead, it imposes a generally applicable exhaustion process for the making determinations with respect to unemployment. I mean, to give the dissent credit, this, I think, would qualify as a neutral rule. I don't think it was written with any sort of hostility to the federal law in mind. It's not certainly obvious that it did. It was written for the same reason that the federal government also requires preemption or requires exhaustion. Go to the administrative agency, go suss them out, and go do that. Although, to be fair, there are exceptions to that requirement even in the federal law. So in the federal law, like, you do have to exhaust your administrative remedies, but if the federal agencies are jerking you around, you can sometimes go to federal court too. So the rule is not as absolute. Although Alabama went for a more absolute version, which, I suppose they can do absolute, right? Why not? The federal government isn't quite as absolute, but Alabama went full fat absolute. I mean, they can do that, generally speaking. And I don't think they did it with the federal law in mind. They just did it because they want to make their courts' lives easier, which, fair enough. There's nothing about this that screams federal hostility to me. The second exemption does not apply either. Alabama's exhaustion requirement is nothing like the statute in Haywood this court viewed as disfavoring federal law. That statute deprived New York courts of jurisdiction over damage suits filed by prisoners against state court officers based on the state's belief that they were by and large frivolous and vexatious, which they definitely are, but that's a problem we can deal with in another way. This court deemed New York's rules effectively an immunity statute cloaked in jurisdictional garb, which protected correction officers from a subset of disfavored 1983 claims, even as New York continued to hear most 1983 actions. According to the Haywood majority, that policy-driven denial could not be squared with the supremacy clause. Fair. I mean, this statute also is not trying to protect certain people. It's not trying to say, like, you need to exhaust remedies with respect to these kinds of state officials versus these other kinds of state officials. The rule is neutral. The rule is general. The rule is broad. The rule is universal as far as it goes. So they didn't do like what New York tried to do. So the precedent from the Supreme Court is not directly on point. It's persuasive, to be sure, but it's not exactly the same thing. The dissent has a fair point. The dissent has a fair point. Alabama's decision to create an exhaustion requirement for all unemployment benefit related claims does not embody any comparable policy judgment. I agree. Rather, this jurisdictional requirement, which has existed since 1939, is ordinary jurisdictional rule reflecting the Alabama Department of Labor's comparative competence over the subject matter. Let's go with that. This exhaustion process serves all the useful functions this court has recognized. It allows the agency with subject matter expertise to retain primary responsibility over the area. It avoids unnecessary litigation, creates a record. In this case, judicial review is necessary. In short, Alabama's exhaustion requirement is a procedural step that promotes judicial efficiency in contrast to the statute, which create de facto immunity shielding. We have no authority to interfere with Alabama's choice. Maybe. I'm a big fan of state level sovereignty. State level sovereignty is important to me. I'm definitely pro federalism. Federalism all the way. And so the Supreme Court is definitely imposing on the states. And so this is a non-trivial concern, particularly to the conservatives. So, fair. And again, it's not that you were necessarily out of luck. You didn't really have a catch-22. You presumably could have filed in federal court. It's like, I don't know why you didn't, but you could have, presumably. And maybe that's good enough. Maybe that's good enough that you can file in federal court. It's like you have a remedy somewhere else. Maybe the state court's jerking you around, file in federal court. You can do that. Did the Alabama Supreme Court address this issue? I don't know whether they addressed it or not, and to some extent, it doesn't really matter. Because, of course, we're in federal level proceedings, and all Alabama can do is clarify its own state law, ultimately. Petitioners try to evade Alabama's exhaustion requirement by arguing for a different exception. On their view, our decisions in Patsy and Felder establishes that states are categorically precluded from imposing exhaustion requirements in 1983. Yeah, that can't possibly be true. But both petitioners badly misread the decisions. Patsy addresses whether federal courts can impose an exhaustion requirement for 1983 cases in the absence of congressional directive. The court held that they cannot, reasoning that federal courts may create exhaustion requirements only where doing so is consistent with congressional intent. So again, in the 1983 case, you're suing state level officials, not a federal agency. All right. So the typical rule, as I said before, is if you're suing an agency, then you have to go through the administrative process first. Right? You have to exhaust your remedies. Some small asterisk apply. And in this case, they said, okay, that rule doesn't apply because they're not suing an agency; they're suing the state level government. And so you don't need an exhaustion requirement there. You do need it for the federal agencies. You don't need it if you're suing under 1983. It's like, okay, I mean, fair enough. That's fine too. Your sources tell you Kurt bought a pony? Who told you? It's a miniature pony. Get it right. It's my new companion animal. That analysis has no relevance to the question here, whether states have authority to establish the structure and jurisdiction of their own courts. Felder, too, is an opposite. That decision held in 1983 preempted a Wisconsin notice of statute that effectively altered the scope of 1983 on the merits. That is, a statute subject the state court plans to dismiss with prejudice if they did not first submit their claims against the state or its officers to the government for an advanced merit decision. Failure to exhaust under that statute operated as a state-created merits defense in 1983, but the impermissibility of such a merits defense says nothing about discretion to create true jurisdictional rules, which only speaks to judiciary's power to proceed at all. I guess. A miniature pony as an animal would be cool. I don't think my landlord would approve, though. But now you've put the idea in my mind. Is a miniature pony in my future? Could be. Felder would remain inopposite even if it involved a purportedly jurisdictional rule compelling dismissal without prejudice. In that event, the Wisconsin statute would simply have raised the problem this court later confronted Haywood when the state singled out disfavored category of claims. The notice claim statute in Felder existed to further the state interest in minimizing liability and the expense associated with it. And although Felder noted the statute imposed an exhaustion requirement, it treated that fact as one of a multitude of interrelated factors that caused the Wisconsin statute to burn the claimants. The exhaustion requirement is not independently fatal. Well, maybe not in that example, it wasn't. So Felder's language on exhaustion should not be overread. I mean, I understand that. Overreading decisions is a problem for many people. The majority rules for petitioners on narrow grounds, but its holding is equally unpersuasive. The majority does not dispute, as a general matter, Alabama is entitled to apply its exhaustion requirement to 1983. Instead, it holds under the relevant law, Alabama's discretion cannot extend to the specific claims here where the challenge delays in exhaustion process itself. On the majority's view, maintaining that exhaustion requirement for such claims would mean that petitioners would never be able to advance in state court, leaving the state essentially immune from challenges to exhaustion. This theory of futility is both forfeited and meritless. Well, if it was forfeited, I'm interested in that, so let me know. This court has almost unfailingly refused to consider any federal law claim to a state court decision unless the federal claim was either addressed by or properly presented. As always, preserve your claims, baby. You use it or you lose it, baby. You use it or you lose it. How are you doing, Bama Law? I'm glad to have you here. Thank you for joining us. Alabama's law school is a beautiful campus. I dropped by there as I was traveling to Texas on my way from South Carolina. I was sufficiently nearby the campus, and so I decided to drop by just to be there because I had never been there before. And the University of Alabama's campus is quite beautiful. So I really like the way that it's set up, and it's really quite nice. So I would not be ashamed to go to the University of Alabama because it looked like a really nice school. So yeah, I went to Akron, Ohio, which is in no sense nicely laid out, and the law school itself was a shithole. The actual building. This court has almost unfailingly refused to consider any federal law challenge. By the way, if Bama Law, if you need a law professor, once again, I am available and more than happy, and I will roll as much as you like, except of course when they're playing Clemson. I do have some other loyalties, but I will wear my maroon with pride, except on Clemson game days, in which I will wear orange. So if we can agree to that much, then I'm definitely interested. This court has almost unfairly refused to consider any federal law challenge to a state court decision unless the federal claim was either addressed by or properly presented to the state court that rendered the decision we have asked for review. In fact, this court's historical practice has generally been to treat this preservation requirement as jurisdictional. Yeah, Dabo for sure, man. He's so cool. Yeah. I wasn't a huge fan of his when he got the coaching job. I didn't think he'd be that good. I was wrong. I was wrong on that one. Yeah. In view of the petitioner's preservation obligation, we should reject as forfeited their newfound theory of futility, which was neither presented nor addressed below. Until seeking certiorari, petitioners litigated this case as a facial challenge, arguing solely that 1983 categorically exempted states from applying exhaustion requirements. So they changed their theory of the case at the federal court. Yeah, then that might be a forfeiture. Then I might agree with forfeiture, that you forfeited the issue by not raising it below. I buy that. That sounds more plausible. The Alabama Supreme Court accordingly understood that the facial challenge was petitioners' only argument for federal preemption. Petitioners belatedly contend they also raised a futility-based argument, but the briefing they cite merely addressed how the futility of waiting for exhaustion affected the proper timing of their facial challenge. Because petitioners raised only a facial challenge below, they cannot press an as-applied challenge here. Fair enough. This I like. This part of the decision I like. This part might get my votes. Yeah, surprising the rest of the court didn't latch on it and punt. I know, Tony, right? I know. Like, that's normally the Supreme Court, one of the Supreme Court's MO. It's like, oh, this is speaking my language. I'm like, this makes a lot more sense. Yeah, it's so surprising the Supreme Court didn't latch onto this and just punt the thing. Yeah, that's more surprising. They actually went past it and decided beyond that. That's different. Facial and as-applied challenges are distinct and must be individually preserved. Fair. So petitioners cannot argue that Alabama's exhaustion requirement is impermissible in the specific circumstances where exhaustion would be futile. Yeah, I that makes a lot of sense. You're speaking a language I understand now. What you were saying before, I wasn't really buying it, but you're speaking a language I understand. There's no reason to treat this case as a very rare exception in which petitioners' forfeiture might be overlooked. The majority, which ignores that petitioners needed to raise their as-applied objections specifically, certainly provides no justification. They don't. Instead, the analysis only highlights why we should not decide the petitioner's as-applied challenge in the first instance. The majority's futility theory depends on the assumption that petitioners will never have their day in court if we leave Alabama's exhaustion requirement intact. But petitioners' failure to raise their as-applied claim below means we have no way of knowing whether this assumption is true. Fair. It may be the case that the exhaustion requirement here contains an implicit futility exception. Or it may be the case that petitioners may obtain mandamus relief, as Dissent below suggested and the state understood. As federal court assessing petitioners' objection in the first instance, we have no way to assess the viability of these or any other mechanisms. Fair enough, man. Fair enough. And incidentally, why they didn't file for a mandamus is interesting. Why didn't they do that? I don't know. That would have been interesting. I'm sure it would have been denied, but still, it's like you got to preserve things. You know what I mean? The majority's attempt to disregard this uncertainty are unpersuasive. The majorities conclude the uncertainty should count against the state and express doubt against the availability of mandamus based on the Alabama Supreme Court's failure to address it. But the court had no reason to opine on the alternative pathways available to petitioner, given the petition failed to raise it as applied. That's really fair. It's like you're not being fair to the Alabama Supreme Court. You're not being fair to the Alabama Supreme Court. They weren't asked, so they didn't discuss it. And they weren't even doing an as applied. They were doing a facial. So there was no reason to discuss it because they weren't saying like, oh, for you, for you, they were saying on its face. Yeah. We should not reward petitioners for their own mistake. Likewise, the majority's assertion that mandamus would be irrelevant even if we're available is puzzling. If petitioners can secure completion of the exhaustion process through mandamus, then by definition, they will not be in a catch-22. Also, you could file in federal court. There's also that. In any event, petitioners' as-applied challenge fails on the merits. All right, so we're going to go from you forfeited it to the merits. I'm still not sold on the merits, so maybe they can sell me on that. I mean, not that it matters. As like every judge, I only need to find the easiest way for me to resolve the case. That's what all good judges do. All good judges find the easiest way. So it's like, oh, you exhausted. What about the merits? What about them? Right? Lol. I don't need to discuss that. I don't need to discuss this because I found an easier way to solve the problem. So we'll push past that and discuss it anyway. All right. Unlike New York statute and Haywood, Alabama's exhaustion requirement is not an immunity statute cloaked in jurisdictional garb. Thank you, Kurska, for becoming a member and being one for 15 months. Properly understood, Haywood directs our focus to the challenge statute's purpose. The court there viewed the New York statute as an immunity statute because it was designed to shield correction officers from damages claims brought by prisoners based on the belief these claims tend to be frivolous and vexatious, which, of course, they totally are. In other words, states cannot implicitly reject the supremacy of federal law by basing jurisdictional limitations, even one that applies to state claims, on policy disagreements. That much I agree with. A focus on statutory purpose makes clear that Alabama's exhaustion requirement raised no Haywood problem. There's no credible argument that Alabama adopted exhaustion requirement in order to defeat challenges. I agree with that. Alabama created its exhaustion scheme in 1939, decades before the understanding that public benefits give rise to due process interests emerged, which is also true, by the way. Yeah, so it wasn't until, when was it? I'm trying to remember. I can't remember when it was. Was it the 60s or was it later? Yeah, it wasn't until a lot later that they said that basically you have a due process interest in government benefits. That wasn't until a lot later. Was it the 60s or 70s? Or maybe even the 80s? I can't remember what decade. But it definitely wasn't 1939, that's for sure. And Alabama's exhaustion process is by all accounts, ordinary exhaustion requirement, common among public benefit schemes, in which the mine run case serves to facilitate the adjudication of benefits determination on the merits. There's no reason to think that Alabama intended to cause mischief in the rare context this presents. That much I agree with. At most, this case presents a circumstance in which Alabama's neutral jurisdictional rule has the effect of defeating the federal claim. But again, our precedent disallows a state jurisdictional rule only if it's in fact not neutral. And this rule is neutral, to be fair to the dissent. That is, if it's based on policy disagreement and so intended to shut the court doors. I mean, I will agree with the dissent. I will agree with the dissent that the precedent does not require this result. The precedent does not require this result. So the Supreme Court has created a bit of new law today. But of course, it is the Supreme Court. That's one of the things they do with their time. But I do agree that this is not just like an extension. This is new territory. So I agree with that much. The majority's contrary conclusion misunderstands Haywood. Ignoring that decision purpose-focused language, the majority asserts that it disallows any state rule that operates as an immunity statute by wholly barring a particular species of 1983 claims in the state court. But in context, that quoted language only reinforces the majority's error. Those lines in Haywood reiterate that what mattered there was New York's illicit purpose. Fair. A state may not deem a particular species of suit inappropriate, nor may a state effectively create immunity statute based on the belief that certain claims are frivolous and vexatious. Yeah, there's another way to deal with that problem. Prisoner lawsuits are almost always frivolous and vexatious, but we can deal with that problem another way. Nothing in Haywood suggests a state rule could be impermissibly just because it has an incidental effect of disallowing certain federal claims. The majority also doesn't grapple with the possible ripple effects of its reading of Haywood. Well, or they're just creating new law. It professes only that its opinion is narrow and does nothing more than resolve the dispute, but the majority's protestations do not make it so. Also true, the label's not the thing. A constraint based on incidental effects is notably more amorphous than our primary focus on statutory purpose. After all, to the extent the Supremacy Clause bars states from enacting nominally jurisdictional rules, in name only, nominally jurisdictional rules that register their dissent from federal policy, states may craft their laws with an eye towards avoiding conflict. But the same is not true for incidental effects. No statute can be perfectly drafted to anticipate every application that ultimately arises, which is one of the reasons, which is what as applied challenges are for. And this is a facial challenge. So also like not appropriate here, presumably. You're gonna do a video on federal claims from prisoners. Some of them are priceless. I believe it, man. Sounds like a fun video. So inevitably, that exhaustion requirement will occasionally slow or defeat claims that we might think as a policy matter ought to go forward. That happenstance is not reason for suspicion, just as we do not malign the many federal statutes with similar categorical requirements. Well, in that case, those requirements are in the federal statute themselves, so that doesn't really make sense. If the statute itself has exhaustion requirements, then that's a different posture. So I don't like that example, but that's okay. I don't have to like everything. Here too, the court should not encroach on Alabama's latitude. I mean, the dissent has a fair point. And the waiver issue is the biggest problem. The forfeiture issue is the biggest problem. And so, like, if the dissent is correctly categorizing the case, and nothing the majority said that they weren't, right? It's like they didn't say, the dissent says that this was, a facial, but it's clearly as applied. They didn't say anything like that, right? So I'm going to assume the dissent is correct. So for me, I think I would join the dissent on that basis. I think I would join the dissent on the basis of, you waived it and it's gone. Try again harder. Sorry. And by the way, incidentally, they can probably just file another lawsuit, like immediately in federal court, because this is an ongoing violation. So there's not even a statute of limitations problem. right? There's not even a statute of limitations problem with this because the injury is still ongoing. I'm still being harmed by this. So you could just file in federal court and try again. Or, or file in state court if you really want to and, do the exhaustion thing or do the as applied thing. And maybe we'll decide it then. So I think I agree with the minority opinion for those narrow reasons. This is fun. I enjoyed this. Attorney Melanie Little is doing some stuff. I'm going to send you over there in a second. Are there any questions, comments, considerations, thoughts? What do you think? What do you think on the issue? This is pretty geeky stuff, though. So, but I'd be interested if you have thoughts, opinions, or whatever. Farther to drive to federal court than state court? Maybe. Well, be that as it may. You don't have to drive that often, incidentally, because you can do a lot of things, on paper. So you don't necessarily have to drive down there that often. What's an incentive for a state to hear a 1983 claim? It's a good question. The biggest incentive for them to do it is just judicial efficiency by trying to resolve all the issues that are related together in one place and avoiding avoiding conflicting decisions from multiple courts. So that's the biggest reason to allow it. It's like, if I didn't allow 1983 claims, then we might have conflicting decisions between multiple courts, and it's also inefficient. So that would be the reason that pops into my mind. Those two reasons. Anything else? All right. Well, thank you very much for joining me. This has been fun. I appreciate you joining me. I'm going to kick you over to Melanie Little to do some more Karen Reed stuff. And we'll go over there for now. And I'm not sure what else we're going to discuss, but we'll do something else soon, I'm sure. I've been on Civil Law. I'll talk to you soon. Have a great one for now, and goodbye.